Hello everyone, I'm Apurva Pandita and welcome to livelaw. As you know that the Supreme Court's Constitution Bench, comprising of Chief Justice of India D.Y. Chandrachud, Justices Sanjay Kishan Kaul, Sanjeev Khanna, B.R. Gavai and Suryakant, has started hearing the batch of petitions challenging the dilution of Article 370, which had given special status to the erstwhile state of Jammu and Kashmir. Our team at livelaw has been diligently preparing detailed daily hearing reports to keep you well informed. We've already made separate videos covering the first and second days of the hearing. And in this video, we will delve into the arguments presented on the third day of the hearing. So let's begin. On the third day of the hearing, that is August 8, Senior Advocate Mr. Kapil Sibal apprised the Constitution Bench, headed by the Chief Justice of India D.Y. Chandrachud, that a unilateral executive decision cannot change the terms of a relationship that is constitutionally embedded in Article 370. Representing the petitioners, Senior Advocate Mr. Sibal submitted that the abrogation was a political decision and thus the opinion of the people of J&K should have been sought before bringing any change. He contended that Article 356, that is President's Rule, could not be used to bring permanent alterations to the constitutional structure of Indian Constitution in its application to Jammu and Kashmir. He stated that President's Rule is meant to restore democracy, not weaken it. He questioned whether emergency power has limits and if it can be used for lasting changes. He also raised concerns about equating constituent power with ordinary power and changing the constitution without consulting the people of J&K, despite a specific provision for consultation. On the third day, Senior Advocate Mr. Sibal basically commenced his arguments by referring to speeches from the Constituent Assembly of J&K. These speeches, including ones by Sheikh Abdullah, Mir Qasim and M.A. Beg, were used to highlight the historical context of J&K's accession to India. Sibal's main point was that an executive decision alone could not alter the relationship embedded in Article 370, which provided this special status. He argued that the abrogation of Article 370 achieved through executive acts like invoking Article 356 and amending Article 367 via presidential orders needed approval from the Parliament. Mr. Sibal compared this situation to Brexit, emphasizing that when relationships are severed, people's opinions matter. But the Chief Justice clarified that in constitutional democracy, people's opinions are expressed through established institutions, not referendums like Brexit. The line of argument then turned to whether Article 370 could become permanent without explicit approval from the Indian Parliament. Mr. Sibal's argument was that if the Constituent Assembly of J&K intended to remove Article 370, it would have done so. He noted that during 1951 to 1957, the Assembly had the opportunity to remove the essence of Article 370, but chose not to. To this, CJI asked whether Article 370, which was initially designed as a temporary provision, be transformed into a permanent one solely through the actions of the J&K Assembly, or did it require an act within the framework of the Indian Constitution, like a constitutional amendment? Moving over to the next argument, the petitioner's next argument centered on the 2019 Constitution Order, which construed or interpreted the role of Sadar-e-Riyasat of Jammu and Kashmir to that of the governor. Mr. Sibal pointed out that no Council of Ministers existed during that period as the state was under presidential rule and the assembly had been dissolved. He accused the union of creating a constitutional myth by assuming the presence of a Council of Ministers even when there wasn't one. He criticized the idea that through an executive order, any part of the constitution could be changed simply due to a majority. He also argued that most Indian laws were already applicable in J&K, making the changes unnecessary except for sending a political message. He said, and I quote, "Then you pass a presidential order that even in absence of Council of Ministers, the governor is acting on its aid and advice. What kind of executive exercise is this? This is a mockery." In response to this, Solicitor General Mr. Tushar Mehta stated that around 1200 laws became applicable post the 2019 exercise, providing equal benefits to the Jammu and Kashmir citizens. However, Mr. Sibal countered that these laws were already applicable under different names. He further contended that Article 367 served as an interpretation clause and not a substitution clause. He argued that using this article to replace Constituent Assembly with Legislative Assembly for abrogating Article 370 was not at all permissible. The Chief Justice asked why amending Article 367 was necessary. Sibal responded that it was done to align the Legislative Assembly's power with the Constituent Assembly's recommendation, emphasizing that the substitution could not be allowed, following the principle that what you can't do directly, you cannot do indirectly. Senior Advocate Sibal also emphasized that while Article 3 of the Indian Constitution allows for the reorganization of states, it does not permit completely transforming a state into a union territory. You can carve a union territory out of a state, but it does not allow the extinguishment of a state. You can carve out a union territory if you have two or more states come together, but you can't create two union territories into a state. Essentially, there are two aspects to that. The text of the Constitution does not allow you to do that, and the fundamentals of constitutional democracy do not allow. Otherwise, this power can be exercised anytime. He argued that such a transformation contradicts the fundamental principles of representative government and constitutional democracy. The petitioner's point was that the authority granted by Article 3 must consider the harmonious balance of constitutional values like federalism, separation of powers, and democracy. During the hearing, the petitioners had also referred to the previous decisions by the Supreme Court, namely Supreme Court's judgment in Sampath Prakash versus State of Jammu and Kashmir, to show that the people who made the constitution for Jammu and Kashmir, that is the Constituent Assembly of J&K, did not want Article 370 to be removed. Another interesting thing to note is that during the hearing, Senior Advocate Mr. Kapil Sibal also made a reference to a speech made by the former Chief Justice of India Ranjan Gogoi in Rajya Sabha to back his arguments. To give a little context, as we know, Mr. Ranjan Gogoi, who was nominated as a member of the Rajya Sabha in March 2020, after his retirement as the CJI in November 2019, made his maiden speech in the Rajya Sabha on 7th of August to support the Government of National Capital Territory of Delhi Amendment Bill 2023, which seeks to dilute the powers of elected Government of Delhi over services. During his speech, Gogoi said that the basic structure doctrine has a doubtful jurisprudence. Referring to this, Mr. Sibal argued that the government's decision to remove Jammu and Kashmir's special status should not be considered right unless there's a new way of thinking that allows them to do it just because they have a majority in power. In this context, he stated, "Now one of your esteemed colleagues has said that in fact basic structure theory is also doubtful." However, addressing this point, Chief Justice of India D.Y. Chandrachud remarked, and I quote, "Mr. Sibal, when you refer to a colleague, you have to refer to a sitting colleague. Once we cease to be judges, whatever we say, their opinions, they are not binding." Finally, while concluding his arguments, Mr. Sibal said, "We stand at a situation where though the Constitution is a political document, its provisions cannot be manipulated or maneuvered for political ends." With this, Mr. Sibal's arguments were concluded after 3 days, and followed by this, now Senior Advocate Gopal Subramanian will be advancing the submissions from the petitioner's side. With this, we have come to the end of this video. We hope that you like our content. And if you do, then do not forget to like and subscribe to our channel. Now you can also support us by becoming a member at ₹89 per month. Thank you.